really pleased to be back. Although you can possibly hear, I'm down by the seaside on the south coast, you might hear the seagulls in the background. So I'm sorry that I'm not there in person with you all, but the advantage, of course, of doing these things remotely is that I know that colleagues are joining from other parts of the country too. So we've had one session already looking at the general position around schools and the Equality Act. And what we're going to do today is focus on the specific question of education, health and care plans, which I'm sure will keep us very busy for a morning. And Sharon and I were just talking on the way in about the SEND review. And of course, there were some questions about what that might mean for EHC plans. But my reading of the review is that there really isn't going to be any kind of radical change to the way that EHC plans work. There's some potentially concerning proposals in relation to school placement choice, although I think that what's in the review actually perhaps begs more questions than it answers. But for now, we're focusing on the law as it is. It will take, if there are to be any significant legal changes, they will take a very substantial amount of time to go through, to be counted in years, I would suggest. So it's really important that we don't lose sight of the current legal scheme and get too excited about what the law might say in the future. And that's something that's been repeatedly emphasised to me since I switched from being a campaigner, as I was back in the 2000s, before I became a lawyer. As a campaigner, of course, you're always thinking about what's going to happen next. But when you're practicing as a barrister, you're very much focusing on what's happening now. So that's what today's going to be about. What does the current law give us in terms of entitlements for children and young people in relation to the EHC plans? So just a couple of points of housekeeping. I can see the numbers are still ticking up, which is fantastic. We've got 71 people on so far. The reason that we're set up, I think, as a webinar is that the Q&A function is really helpful for me, primarily, in order to keep track of what I'm being asked. So please do use the Q&A to put any questions you have for me about the content of the talk. Feel free to use the chat function, which I think will be monitored for any kind of process type questions. But the Q&A is where I'd be very grateful, please, if you could put your questions. Those of you who are new to Zoom, if there are still people that are new to Zoom, it's down at the bottom of your screen. And what's very important, as Simon mentioned on the way in, is please keep the questions as short as you can, because I've got to read them. And obviously, if you write me an essay, then that's going to rather delay things. But also, please try and make them general, because I can't give case-specific advice today or on any of these talks. People will immediately see, I'm sure, that wouldn't be appropriate for me to do. Whenever I do give advice, the very first thing I'll be saying is, right, I need to understand the detailed facts of this particular case, because everything in this world is so fact-specific. So all I can do today is give a general steer as to what the law might require. And so please ask general questions that I can give general answers to. Of course, they can be hopefully relevant and useful to you, but please try and make them as short and general as you can. And please do recognise that anything I say today is not to be taken as legal advice. That's my lawyer's disclaimer at the beginning. Another important preliminary point I'd suggest is that EHC plans were never intended to be and are not for all children and young people with special educational needs. We will see very shortly that there is a legal test for when a local authority must issue an EHC plan. And the bar is set relatively high for when an EHC plan is required. So it shouldn't be assumed that just because your child or young person has special educational needs, they must have an EHC plan. To try and give it a useful shorthand, EHC plans are essentially reserved for children and young people with significant special educational needs that requires significant additional provision over and above that mainstream schools will usually make. So it may well be that your child has a diagnosis and is clearly identified as having special educational needs, but it may well be entirely appropriate that those needs are met through school action, through SEN support. Sorry, I'm showing my age, which is the process that's set out in the Code of Practice, whereby schools are intended to meet the majority of special educational needs. So we're dealing here with children who have face significant barriers to accessing education as a result of a learning difficulty or learning disability. So that's an important health warning to keep in mind, because not everyone needs or will get an EHC plan. There is, of course, I would suggest, a group of children who need an EHCP plan who don't get one, and those are the ones that perhaps are particularly concerning, and where often lawyers like me may get involved to challenge local authority decisions. So that's an important caveat I would suggest before we kick off. Now, what we're going to do is I'm going to take you on a little bit of a tour of the law itself, because one of the great advantages of doing these talks remotely is I can actually show you the law via the screen. So I'm going to share my screen, bring up a web browser, making sure I've closed everything that might be remotely confidential. Hopefully you can now all see my Google Chrome homepage. What I'm going to do is I'm going to just search. Other search engines are available, but I'm using Google Children and Families Act 14. I want to show you how easy it is to see the law itself. So there you go. What you're looking for is legislation.gov.uk. That's the official source of the legislation. And so we can see immediately what Parliament has said about provision for, as it says in Part 3, children and young people in England with special educational needs or disabilities. And that itself is a slightly misleading title, because you'd be forgiven for thinking, if you read that all of the law about children and young people in England with special educational needs or disabilities is here in Part 3 of the Children and Families Act. It's not. There are still very important legal provisions elsewhere. For example, everything to do with social care essentially is elsewhere. The Children Act 1989, the Chronically Sick and Disabled Persons Act 1970, we're talking about that in another talk. But in terms of the scheme for EHC plans, that's all here. So Part 3 of the Children and Families Act, replacing the old system in terms of statements of special educational needs, created this concept of an EHC plan. But before we get there, there are some other important definitions that we need to understand. So to start with, we need to understand the definition of special educational needs. Apologies for those of you who this is already familiar, but this is the basic building block of the scheme, that a child or young person has special educational needs if he or she has a learning difficulty or disability which calls for special educational provision to be made for him or her. So you have SEN if you need SEP as a result of having a learning difficulty or disability. So that phrase calls for is well understood and was in the previous legislation. So then we need to understand what it means to have a learning difficulty or a disability. And there are two possibilities here. So you have a learning difficulty or disability if you, first of all, have a significantly greater difficulty in learning than the majority of others of the same age. So you can have a learning difficulty if you are in the 51st percentile of people that have difficulties. It's got to be in the majority of others of the same age. And then secondly, the other way is that you have a disability which prevents or hinders you from making use of facilities of a kind, generally in mainstream schools. So it's either that you have a significantly greater difficulty in learning, and or, because many children have both, of course, you have a disability that prevents or hinders you from using the facilities that you will find in mainstream schools or colleges, depending on your age. So that's the definition of special educational needs. But in order to understand it, of course, we then need to understand what special educational provision is, because it's got this learning difficulty or disability, has to call for special educational provision. Special educational provision is educational or training provision that's additional to or different from, another very well-worn phrase, that may generally, for others of the same age, in mainstream schools in England, generally, or nurseries or colleges. So one important point here is that the comparator now is nationwide. So you require special educational provision if you need provision that's additional to or different from what's generally made available in England, not just in your local area, or if you're under to educational provision of any kind. But other important definitions here: healthcare provision and social care provision. Healthcare provision is anything that's provided by the NHS. Social care is anything provided by a local authority under one of the social services functions, primarily here, Children Act 1989. But very important, section 21(5). Healthcare provision or social care provision, which, I'll just emphasize these words, educates or trains a child or young person, is to be treated as special educational provision instead of health or social care. So that's why, for example, speech and language therapy is almost always special educational provision, because although it may be funded or commissioned by the NHS conceivably by a local authority, it is in practice educating or training the child. And so that's the only question you need to ask. Does it have the effect of educating or training the child? If it does, then it's special educational provision, and it falls in that part of this scheme. So those are the two key points of definition. Come back out, and we can skip through some of the more general duties on local authorities. We see that the concept of an education, health and care plan is introduced here at section 37. And so from section 37 to section 50, we have provisions in relation to EHC plans. But before we get there, we've got to look at section 36, because that's the duty to assess. So as with almost everything to do with social welfare law, the gateway to getting an EHC plan is an EHC needs assessment under section 36. That's the first thing we'll look at. And we see, first of all, under 36.1, that a request for a local authority to secure an EHC needs assessment may be made to the authority by the child's parent, the young person, so a 16-year-old or above who has capacity, or a person acting on behalf of the school. So that to deal with one myth immediately, there is no requirement for the request to be made by the school. The parent or the young person have the right to make the request. And then we get a definition of what an EHC needs assessment is. It's an assessment of the educational, health and social care needs of a child or young person. Some provisions that follow in relation to the process. But what we need to understand most importantly is the test. So what questions must the local authority ask and answer when deciding whether to carry out an EHC needs assessment? So a parent generally has asked for their child, say, let's take a common example, an autistic child, perhaps age 5 or 6, who's got a diagnosis relatively recently, to be assessed under section 36. So the local authority must secure an EHC needs assessment, and must means that it's a duty. There's no wriggle room, it's not a power, not may, it's must secure an EHC needs assessment if, after having regard to any views expressed and evidence submitted by a variety of people, including the young parent and or the parents, young person or the parents, they're of the opinion that, so they have to form a view, that first of all, the child or young person has or may have special educational needs. Well, I understand why that's there, but that's an incredibly low bar, because at this stage, the local authority's opinion would only have to be that the child might have SEN. Well, frankly, it's hard to imagine a situation where anyone's going to be asking for an EHC needs assessment to be carried out if there's not even a realistic prospect that the child has SEN. So I would be very surprised if a local authority properly directing itself would ever refuse on that basis, but I suppose it's conceivable. So the real issue, the real question is B, it may be necessary for special educational provision to be made for the child or young person in accordance with an EHC plan. So there's three key parts here. First of all, it may be necessary. So the threshold is might. It may be necessary, i.e. a realistic prospect, a prospect that is more than fanciful or remote. So it's not a particularly high bar. 4, importantly, special educational provision. So I'm going to be showing you throughout this talk that the Children and Families Act and the EHC plans are essentially an education-focused scheme. And this is one of the key building blocks of that argument, because you could have, as a child or young person, the most complex care needs, health needs, and you would not be entitled to even an EHC needs assessment unless you've got significant special educational needs which require significant special educational provision. So the gateway is focused solely on SEP, a requirement for special educational provision, to be made for the child or young person in accordance with an EHC plan. So it's not just that it may be necessary for the child or young person to have some special educational provision, because that's what's supposed to be done through SEN support. What has to be shown is that it may be necessary for special educational provision to be made for the child or young person in accordance with an EHC plan. So why might it be necessary for a child or young person to get their SEP via an EHC plan? Well, the legislation doesn't define the reasons, but the code of practice and the case law suggests at least 2 likely scenarios. One is that the child or young person may need to go to a special school, because if they may need to go to a special school, or it may be appropriate for them to go to a special then they will require an EHC plan to go there. Another very likely scenario is that the provision that they may require may be more expensive than the school can afford. And the figure people will be aware of in the notional SEN budget for mainstream schools is £6,000 a year. So, for example, the child or young person may need a full-time one-to-one support worker. That's going to cost more than £6,000 a year. The child or young person may also, or alternatively, need a significant amount of speech and language therapy. It could cost well more than £6,000. So there would have to be a realistic prospect of a substantial amount of special educational provision being required, which it isn't reasonable to expect the school to fund. But again, at this stage, the threshold is only that it may be necessary. There are other, I think, valid reasons why it may be necessary for provision to be made in accordance with the EHC plan. For example, the provision is relatively controversial or relatively complex and intricate, and it's appropriate for it to be written down and described in a legally binding document that everyone signs up to. That could be a reason, even if it's not particularly expensive. So there's no closed list of reasons, but the two that I've started with are going to generally be the reasons that are given, that are relied on. Either the child might need to go or may want to go to a special school, parents may want them to go to a special school, or that the provision is relatively expensive, or maybe relatively expensive. And then what we see here is decisions as to what you do next by the local duties as to what you do next in terms of notification, and then also very detailed requirements as to what the regulations may say. We'll come on to the regulations shortly in terms of fleshing out the detail of the duties in this area. But that's it in terms of primary legislation, in terms of what the Children and Families Act says in section 36 about EHC needs assessments. Now, the reality is that almost every case where a child or young person is refused an assessment, which is appealed to the tribunal, results in either the local authority agreeing to assess or the tribunal ordering them to assess. It's well up into the 90%, 96%, I think is a figure off the top of my head. So there does seem to be an issue with local authorities applying overly rigid tests, overly rigorous tests here, and coming up with their own criteria, which are not those that are reflected in section 36.8 here in A and B. And essentially where the local authorities do that, they may well be acting unlawfully, but because there is a remedy available, which is the right to appeal to the tribunal, it's very difficult to actually challenge unlawful practice in this area through the High Court, through judicial review, because there's always an alternative remedy of individuals going to the tribunal. So that certainly is something that would be very helpful if the SEND review resulted in better practice, in my experience. So I'll just pause there and have a quick look at the Q&A, see if there's anything that's come in on the EHC needs assessments. So question, why do the local authority only consider educational attainment? That's supposed to include social, emotional, mental health. And that's right, it is, but only in relation to special educational needs and special educational provision. And as we've seen, that's because of section 38, focusing solely on special educational provision. So if your child has social, emotional, mental health needs that result in a requirement for additional educational provision, being anything that educates or trains them, then that should be enough. But if the social, emotional, mental health needs don't require educational provision, then that won't be taken into account at this stage. Should be at the later stage when we're looking at the content of the EHC plan, but not on the question as to whether or not they should get an EHC plan in the first place. And to try and give a slightly more helpful response to that, I'll just take you to another important guidance document on children with medical needs. So it's supporting pupils with medical conditions at school. Statutory guidance about the support that pupils with medical conditions should receive. We talked about this in the last of these sessions when I was looking at the wider duties on schools. But essentially what this document requires is for schools to take significant steps to meet children's medical needs that would otherwise prevent them from being in school. And there's a very snappy set of 3 key points here. Pupils at school with medical conditions should be properly supported so they have full access to education, including TRIPS and PE. Governing bodies have to ensure that arrangements are in place in schools to support pupils with medical conditions and there should be consultation with health and social care professionals, etc. And the guidance later on talks about involving clinical commissioning groups, involving the NHS in the most complex cases. I hope that's of some help for that wider group of children and young people. Looking at if there's any other questions about EHC needs assessment at this stage. So a question that picks up my point about section 21, subsection 5 on this question of educating or training. Does OT also educate or train a child? So does occupational therapy also educate or train a child? It seems to me that the answer to that question is almost always going to be yes, because those terms, education and training, have ordinary meanings. They're not defined. And it seems to me that any of the therapies that involve trying to support a child to do something better themselves is likely to be educating or training them. And in that case, as we'll see, that means that OT should go in section F of the EHC plan. If somehow the OT is not educating or training the child, then it will go in section G, which is the health provision. And health provision, as we're going to see, is enforceable as well, although it's enforceable against a different body. Specifically the clinical commissioning group. An interesting question, is it true the application for an EHC needs assessment has more authority if it comes from a school rather than a parent? As a matter of law, absolutely not, no. It should be treated in exactly the same way. As a matter of practice, I can see why it may be helpful either for the school to make the application, or I perhaps would prefer to go down this route, for the parent to make the application, but with a letter of support from the school. Because one of the first questions the local authority will be asking is, well, why can't the school just do this? Why can't the school meet needs? And if the school are explaining why they can't do it, then that helps meet the second part of the test, which is that it may be necessary for an EHC plan to be issued in order to meet the child's special educational needs, in order for the provision to be made. So no in law, but perhaps in practice is the answer to that question. If toilet training is mentioned in section B and F of the EHC plan, which is the education section, does that mean that section 21 subsection 5 has come into play? Quite possibly yes, because I would say toilet training classically is an example of educational training, isn't it? In terms of trying to support a child to be able to better meet their toileting needs. There's lots of questions that I'm also very tempted to answer, like what happens if the school doesn't follow what's in the EHC plan. But I'll come on to those points shortly, because we haven't got yet to even to the contents of the plan, never mind what the remedy will be. And there is a remedy if a school doesn't do what's in the EHC plan. Interesting, a local authority tells parents there is no additional money available with an EHC plan. Money should be accessed through high-level need funding for children with SEND. Many EHC plan applications are refused because of this. Is this okay? Well, I'm not going to give advice, and I'm not going to comment on what a particular local authority is doing. But what I will say is that you've seen the test for an EHC needs assessment, and money, resources, is not mentioned as any part of the reason why an EHC plan, an EHC needs assessment application should be accepted or refused, or indeed when we get to the question of whether a plan should be issued. So I struggle to understand that as that form of reasoning. We're also going to see that if an EHC plan is issued, then the local authority has the duty to secure all the provision in it, regardless of the cost. So I would suggest anyone who's being given that reason should definitely take some advice. A question, is there any legal standing for the graduated approach, or is this a local way to delay the process? There is, because we'll see when we get to the code of practice that the concept of SEND support, SEN support, is very much embedded in the code. And we've seen that the test for when an EHC needs assessment has to be carried out is whether it may be necessary for the provision to be made in accordance with a plan. And so inevitably the question is, well, why can't it be done by the school? So absolutely, there is a legal basis for saying, no, we take a graduated approach. But there will be cases where it's entirely inappropriate for a child to be made to wait for an EHC needs assessment. And maybe there are cases that are blindingly obvious where an EHC plan is going to be required. The child may well be 18 months or 2 years old, and that may be obvious. So it certainly can't be used as a blanket approach. But yes, in principle, a local authority is entitled to say that they want to know what the school's been doing and why the school-based stage of the code of practice isn't sufficient in this particular case. Oh, one of my favourite questions about section 21, subsection 5, and I'm not at all sorry to be asked several questions about it because it's such a key provision. The question is, can CBT by a clinical psychologist for a young person who's autistic and has agoraphobia be included in section 8? So CBT is cognitive behavioural therapy. And my view, and this is only my view, is it probably can be, yes, because I think CBT is training in that it's a structured program of intervention that's intended to achieve an outcome in terms of the ability for the young person to better manage their emotions and so on. Whereas perhaps more traditional psychotherapy, Freudian, Jungian style psychotherapy, maybe that's not educational training because it's not structured, it's not a program, there's no specific intended outcome. But the question is always a factual question to be answered on the facts of the specific case. And the question is it educating or training the child or young person, or would it if they're not currently receiving it? But it certainly seems to me in relation to CBT, you can make a very good case that it is or would be educating or training them. And an interesting question, once the school or the parent has made the application, the local authority has to reply within a time frame. What happens if you don't get a reply? Now, that does bring me on to a very important question, which is, sorry, 1 second. Sorry, everyone. I've got a barking dog and I'm trying to avoid everyone having to listen to. Just give me 1 moment, I'll be back. Sorry about that, everyone. The quickest way to deal with that was going to be to answer the door, so that's what I did. So the question that we were looking at was, what happens when local authorities don't respond in time? And the answer is that that's a situation where the only legal remedy is judicial review. Now, judicial review is the process whereby the High Court scrutinises the lawfulness of decisions, policies, actions by public bodies. And it's understandably, because it's in the High Court, rather a challenging process. It's expensive, it's involves potentially a risk of paying very significant costs if you lose. Quite a lot of my work involves judicial review. And in most cases, the claim will be funded by legal aid. So legal aid is still available. And the child or young person may be eligible for legal aid. Although in this area, the difficulty is that a lot of the rights vest in the parents. And so the question is, are the parents themselves eligible? So all I can say is it's well worth looking into whether you can access legal aid. And I will put a link in the chat to my blog, which has a list of some of the solicitors who have the relevant legal aid contracts. Oh, sorry, I've just sent that link to the hosts and panelists. I'll send it to everyone now. So that link there that's hopefully come through is to my blog, which has a list of some of the solicitors that have legal aid contracts in this area. So the short point is, if you think that a local authority is acting unlawfully, then you need to get advice as quickly as possible from a specialist in this area. There are also, and their details are on the blog too, very good advice organisations, of course, both the local CENDIAS services, which in some areas are independent of the local authority structurally as well as formally, and provide very, very good advice. And there's also charities like EHCP and SOS SEN. But ultimately, if you want to bring a legal claim, you're going to need to fund it. And most of the time that will need to be via legal aid. Otherwise, there are alternatives like crowdfunding through the Crowd Justice website, but that's very difficult to use for individual cases. It's more successfully used where you're trying to challenge policies, particularly at the national level, frankly. So thanks very much for those excellent questions. I've been through those that I've got time to deal with now. What I'll look at next is the duties in relation to EHC plans themselves. So if we look at section 37 of the Act, just been looking at section 36 on assessment, 37 tells us about EHC plans themselves. And as you'd expect, starts from the assessment. So where in the light of an EHC needs assessment, it is necessary for special educational provision to be made for a child or young person in accordance with an EHC plan. So that's now the test. The local authority must secure that an EHC plan is prepared. And once it's done that, it must maintain it. So the question at the second stage is whether it is in fact necessary, balance of probabilities, more likely than not, for special educational provision to be made in accordance with an EHC plan. And the same factors will apply. And so it's here that we get a definition of what an EHC plan is. It's a plan specifying SEN, outcomes, SEP, healthcare provision, social care provision, and we'll see shortly also the placement that the child will attend. Outcomes was new, of course, very important point. Before this scheme, we didn't have a focus on the outcomes that we were trying to achieve. So section E of an EHC plan is entirely novel, but there were previous sections in relation to education health needs and provision, although only the educational aspects of a statement of SEN were enforceable. And again, we see then reference to the regulations, which we'll come on to look at in just a moment. So that's the basic scheme in relation to the EHC plans. There was a question about draft plans, and we see that where a local authority is going to secure that the EHC plan is prepared, it has to consult the parents of the young person about the content of the plan during the preparation of a draft. And it has to then send the draft plan to the parent or young person and give them the notice of their right to make representations about the contents, and at this stage, request a particular school or institution within subsection 3 be named in the plan. And that means maintained schools, academies, non-maintained special schools, colleges, and so on. And the draft plan mustn't name the school or institution or the type of school or institution. So it's at that stage of the draft plan that the discussion is supposed to take place in relation to the particular school or type of school the child or young person is going to attend. And if the parents or the young person do make a request for a particular school or institution, the local authority must consult that school, as you'd expect, and then the local authority must secure that the plan names the school or other institution unless one of these exceptions apply. So these are the legal exceptions from the duty to name the particular school that the parent generally has asked for. So the first exception is that it's unsuitable for the age, ability, aptitude, or SEN of the child or young person. So the school is unsuitable for that particular child or young person. That's not generally the point that's relied on. Generally, the point that's relied on is here in 4B. The attendance of the child or young person at the requested school or other institution will be incompatible with, so take note of that, it's a high bar. So to be incompatible with the provision of efficient education for others. Now, that is sometimes relied on. We can't let Johnny attend this particular school because his behaviour will be such that the other children wouldn't learn a thing. It has to be that high because it has to be incompatible with the provision of efficient education for others, taking into account the duty on the school to make reasonable adjustments for that child. Sometimes comes up, but not the priority. Not the usual issue. The usual issue is cost, as we see. Incompatibility with the efficient use of resources. So that doesn't simply mean costs a pound more. The difference in cost has to be such that it would be incompatible with the efficient use of resources for the local authority to pay it. As a very rough rule of thumb, you might succeed on a cost difference that's less than £10,000 a year if you can show that the benefits to the child of the particular school are so great that even if school B is barely suitable, it was still not inefficient to spend the extra money on school A. But anything over £10,000, I've never known anyone succeed in the tribunal or otherwise in arguing that. If it's less than £5,000 a year, you're much more likely to succeed, I would suggest. So you can see it's got to be a relatively close call. Even better, of course, if once you've looked at the numbers carefully, you can show that the costs of your school are less than the costs of the school the local authority are putting forward. But the difficulty there is that the case law shows that maintained schools and academies are the basic place cost is treated as zero, whereas non-maintained or independent schools, the full package cost is taken into account because it's the additional cost of a local authority of that particular child going there. So very often where that's what parents want, the cost difference is many times more than £5,000 or £10,000 a year. It could be £50,000 a year or more. What happens in those cases? Well, in those cases, what the local authority and ultimately the tribunal are looking at is whether the local authority's school is appropriate for the child, is sufficient, is adequate, will meet need. And if it will, then that's really the end of it, because the cost difference is so great. And so what parents are then left having to try and do is prove, on balance, that the local authority's school can't meet the child or young person's needs. And the usual way of doing that is to obtain independent evidence, particularly from an educational psychologist, who can provide a report and come to the tribunal to explain why the school that's being put forward isn't in fact suitable or appropriate. Now, that obviously has very significant costs associated with it. The good thing about the tribunal process is that you very, very rarely will be asked to pay any costs for the other side, vanishingly rare. The tribunal is essentially a cost-neutral jurisdiction. So you'll have to pay your own costs for lawyers and experts if you have any, but you should not expect to pay the other side's costs. You'd have to do something wholly unreasonable in the process to be expected to pay any costs to the local authority. But on the other side, it's very difficult to get any costs back from the local authority. And again, they would have to have behaved wholly unreasonably. And for example, just having a very weak case and the school being pretty obviously unsuitable isn't necessarily wholly unreasonable, the tribunal has said. So you have to show that you have to prove the negative. You have to show the local authority's school can't meet needs if the local authority are relying on this exception here, and that's going to require evidence which it will generally fall to the family to fund. Reports are available through legal aid, through the legal help scheme for those parents who are eligible for legal aid. But that will only be a small minority because the thresholds for accessing legal aid are unfortunately set very low in terms of the amount of money the family need to have, whether that's in terms of income or savings. So that's the usual exemption that's applied. Is we're not going to name the school that you've asked for because it's too expensive. If that's what's applied, then the local authority has to follow here subsection 5. They have to name another school or type of school that they think is appropriate. And before they do that, again, they have to consult any schools that are being considered, and then ultimately send a copy of the final plan to the parent or the young person and the relevant school. So that's section 39. Section 40 applies where there hasn't been a request for a particular school or institution, quite rare, of course, because normally parents or young people will have well in mind where they want to go, where they want their child to go. But it can happen, and in those cases, the local authority again has to name what it thinks will be an appropriate school. Section 41 allows the Secretary of State to approve special schools and post-16 institutions and put them on the list, which means that they fall within that scheme, and very many of the independent schools are on that list. And again, you can literally Google the list. Google Secretary of State approved list, section 41, up it comes, and see if the school you're interested in is on that list. And then we have section 42, which is hugely important, because in answer to the question of what's the point of EHC plans, you essentially need to point to section 42 in the first instance. And it says that where a local authority maintains an EHC plan, the local authority must secure the specified special educational provision for the child or young person. So section 42, subsection 2, is the duty to secure the specified SEP. And so that's why it's so important that the wording of the EHC plan is right, that you've got properly specified and quantified wording that describes provision that will actually be made for the child or young person. So if it's speech and language therapy, for example, it doesn't say access to speech and language therapy as appropriate, because that's meaningless. It says that Johnny will receive 1 hour a week of speech and language therapy directly from a speech and language therapist or from a speech and language therapy assistant, and that person will have X amount of experience and X or Y qualifications and so on. So appropriate levels of expertise, levels of specification and quantification must be included within every EHC plan. And we'll see a little bit more about that when we get to the wording of the Code of Practice. So that's the first hard-edged duty that applies to every EHC plan. All the provision, the special educational provision in section 8 must be secured. It's a no excuse duty. There's no wriggle room. It just has to be done. That wasn't new. That's the same as for statements. But what is new is here, 42.3. If the plan specifies healthcare provision, of course it may not, because the child may not have any health needs, the responsible commissioning body, which will generally be the CCG, must arrange the specified healthcare provision. So it's the same duty. Now, the reason it says arrange rather than secure is that commissioners, like the CCGs, don't actually provide anything themselves. It's always arrangements made with other people. But it's still, very clearly, in my view, a individual specific duty to make sure that any healthcare provision that's in section G of the plan is always arranged. And the only exceptions given is subsections 2 and 3 don't apply if the child's parents or the young person have made suitable alternative arrangements. Otherwise, it has to happen. The other reason why EHC plans are so important is section 43, because schools and other institutions named in the plan have duties to admit. And so any of those types of school, for example, the approved schools on the section 41 list, or not maintained special schools or maintained schools, academies, must admit the child or young person. And that goes ahead of any other obligations in relation to admissions. So inevitably, of course, an EHC plan is a snapshot. It's a record of the needs and the provision at a particular point in time. And so it's necessary that local authorities review plans and potentially reassess. So the requirement for an annual review is here in the primary legislation in section 44. A local authority must review an EHC plan that it maintains every 12 months. So that's a specific statutory duty. And it should be completed, of course, within the 12 months. Otherwise, it's not an annual review. So that's the annual review duty. At 44.2, the local authority must secure a reassessment if they're asked to do so by the parent or the school, subject to any contrary provision in the regulations. And we're going to see what the regulations say. Essentially, they don't have to reassess unless they consider that a reassessment is necessary. And so in the vast majority of cases, it won't be necessary to make a reassessment because there hasn't been a fundamental change in need. And instead, the process can be dealt with through annual review of the plan. It will only be essentially where there's been a case of a very significant development that the local authority will need to go back to the beginning and fully reassess. Local authorities don't have to maintain EHC plans forever. Section 45 deals with scenarios where they can cease to maintain the plan, either because they're no longer responsible for the child or young person, i.e. they've moved away, or they consider that it's no longer necessary for the plan to be maintained. That can include because they no longer require the SCP in the plan. And very important here, that in deciding whether a young person requires the SCP and therefore the plan should continue to be maintained, the local authority's got to look at whether the educational or training outcomes have been achieved. And so that's one of the reasons why outcomes are really important, because if the outcomes are vague and woolly, it'll be much easier for a local authority to say, well, yeah, they've been met. There's an ongoing debate with the tribunal about whether the tribunal has jurisdiction to order amendments to the outcomes. My view is they clearly do, and the upper tribunal has said they do, but only in consequence of amendments that are being ordered to the special educational provision or potentially other provision being recommended in health and social care. So, well worth asking and getting advice on whether you can try and challenge the outcomes in a plan through the tribunal process. Otherwise, the only remedy would be judicial review. I'm not sure if in practice any judicial review has ever been brought in relation to inappropriately worded outcomes in the EHC plan, but it's certainly at least a possibility. And we see that if a parent or young person appeals against the decision to cease to maintain a plan, then the plan has to continue here at 45.4 until that appeal has been determined. There's a provision that allows plans to be continued after the age of 25 to enable the young person to finish their academic year. EHC plans can be transferred to different local authorities in accordance with the regulations. See that shortly. This is about children and young people in youth detention, which is not a group that I'm going to have time, unfortunately, to cover today, but I'm happy to take any questions on that. Personal budgets and direct payments. So under section 49, a local authority that maintains an EHC plan or is preparing one must prepare a personal budget for the child or young person if asked to do so. So there has to be a personal budget prepared on request. And a personal budget is described as an amount as available to secure the special educational provision that's specified or proposed to be specified, with a view to the parent or the young person being involved in securing the provision. So, as we'll see, there are some separate regulations about personal budgets. They are not necessarily going to be a direct payment, because we see that direct payments can be all or part of a personal budget. But a direct payment is the type of personal budget where the funding actually transfers to the family to pay for services themselves. The reason why they're relatively rare in this area is because if it would cost the local authority more to do it that way, they're not allowed to make a direct payment. The power is taken away. And often it will cost the local authority more to do it that way than to use a commissioned service. So it's actually quite difficult to require a local authority to make a direct payment, but it's much more straightforward, as we see, to get at least the sum that's going to be spent to secure the provision identified through a personal budget. Lots of detail here that I won't go through just for reasons of time. And then section 50 is really important, although it's quite geeky, because what it requires is that where an EHC plan is being maintained, the child is entitled to children's social care services until they've fully transferred to adult social care under the Care Act. So there's no cliff edge between children's and adults' social care. So that takes us through the key provisions in relation to EHC plans. The next thing to think about is, okay, how does the tribunal fit into this? Before we look at that, let me just deal with some questions, see if there's any other questions on the contents of the EHC plan. Would an extra year for a student at A-level be in section F? Yes, if it goes anywhere, then it has to be a special educational provision, doesn't it? Provision that's additional to or different from that which other children get. The question that a school is refusing to do an educational psychology review. What's the procedure and who's responsible? Well, the school's got no obligation here. All of these duties, as we've seen, are on the local authority. The school, as under the regulations, has to participate in annual reviews, but it certainly doesn't have to ask an EP to be involved. So one of the key myths, again, about the system is that schools are expected to take the lead. They're not. It's a matter for local authorities in almost every case. How could you get a private school that's more suitable than the local authority funded one? Well, as we're going to see, the answer to that is almost certainly that you're going to need to appeal to the tribunal and persuade the tribunal that the local authority school is unsuitable or inappropriate for your child. What happens if a post-16 college is named? There's a conditional offer and the conditions aren't met. Well, under section 43, as soon as a college is named in an EHC plan, they have to admit. So again, I think all I can say about a case like that is it will be well worth taking some case-specific advice. How do you hold local authorities accountable? Placement starts, but the plan isn't finalised, naming the placement. Again, the remedy there would have to be a judicial review, because failing to do any of these things at all or in time is not something the tribunal can engage with. It's only there to deal with the final decisions and challenges to those final decisions. And it is quite common, sadly, that parents have to at least threaten judicial review to get a local authority to complete some of the steps in the process. How do you evidence incompatibility of resources? Well, you don't have to evidence incompatibility of resources. It's for the local authority to say, no, we're not going to name your chosen school because to do so would be incompatible with the efficient use of resources. And you have to say, well, no, it wouldn't be, either because actually the cost difference is very little, or because your school local authority can't meet need. Very helpful question, thank you, about home education. So what we've seen, and we'll see in more detail when we get to the regulations and the code, is that the duty in relation to section F to secure the special educational provision is not hooked to the child or young person going to a particular school or college. And it's very possible, and the tribunal and the upper tribunals confirmed this, for section I of an EHC plan to be left blank if it's agreed or ordered that it's the child or young person shouldn't go to school. And we'll look at the statutory provision in relation to that in a moment. And in those cases, there will be what's described as an EOTAS package, education otherwise than at school, which will often be at home. And in that context, the local authority will be required to secure the provision at home or otherwise in accordance with the wording of Section F of the EHC plan. Another really interesting question: what about a situation where a local authority says that a school can meet a child's needs, but it's a faith school and the family do not have any faith, they're atheists? It would be perfectly open to the family in that situation to argue that it's not therefore a suitable or appropriate school. If the local authority don't agree, that's a matter that the tribunal can ultimately determine. There's also a very interesting question there about potential indirect discrimination, or even direct discrimination on grounds of religion, because not having any religious belief is also a protected characteristic under the Equality Act. But I would suggest, again, that's something that you need to get specific advice on. On the Section 42 duty to secure the provision, if the local authority doesn't update the EHC plan following a review, what's the legally binding SCP? The legally binding SCP is what's in a final EHC plan. So the local authority has to essentially update the EHC plan to then trigger the new Section 42 duty. And if it doesn't do that, then it will be open to the school to judicially review the local authority and or the parents. What about if parents don't engage with the review? Well, that's really a matter for the local authority and the parents to resolve. Schools obviously have to put forward their own evidence about how much progress has been made, whether the needs provision and outcomes need to be updated and so on. But then it's a matter for the local authority to complete the annual review with the best evidence it can. Can a small education setting, a nurturing approach, be included as provision within an EHC plan? Yes, the first, definitely. Class size is commonly included as a form of SCP in Section F of the EHC plan. A nurturing approach, I think, is difficult because what does it mean? What I would always be asking is, how, as your lawyer, could I come along and try and enforce that? Because it would be very easy, I think, for many schools to say, we have a nurturing approach. So what you're looking for always is, as best as possible, to quantify and specify the provision that you're asking to be made. Question about EHC plans going to 25, that is the maximum age, but there is this extension to the end of the academic year the person turns 25 that may be relevant in some cases. If a local authority refuses to make a personal budget for speech and language therapy services, for example, what action can a parent take? Judicial review, because again, that's not an issue, as we'll see in a moment, that can be appealed to the tribunal. A question about who should carry out an emergency review. Again, obviously, the local authority, because all of the duties in relation to EHC plans are triggered, are owned by the local authority, save for the duty to admit under Section 43, which is obviously a duty on the school. Wraparound provision after school clubs to support working parents that are open to other children. Could these form part of an EHC plan? Well, they could, if attending that club was seen as special educational provision to meet one or more of the child's special educational needs. But I think it's much more likely that that wouldn't be SCP because it's the same provision as other children are getting. And in that case, what you'd be looking at is the reasonable adjustments duty and the other Equality Act duties on schools, which I covered in the previous session, to make sure that that offer is accessible to disabled children. An interesting question about foster carers. In a situation where a child has a foster carer and is looked after by the local authority, would it be the social worker who applies for an EHC plan? Very difficult question, to which I think the answer is yes, because a request has to be made by a parent, and the person with parental responsibility in that scenario may well be only the local authority, and therefore it would have to be the local authority asking itself to carry out an EHC needs assessment, which has obvious potential conflicts of interest. Can a mainstream school refuse to make reasonable adjustments for a child with an EHC plan? Well, no, in the sense that if the provision is in the plan, the local authority has to secure it. And that therefore means the local authority has to make sure that the school is doing it, essentially. However it does that is a matter for it. If it's adjustments that are beyond what's in the EHC plan, then the question will always be, is that reasonable for the school to to do it. And on that, I'm going to need to refer people back for reasons of time to the previous session. Can a local authority refuse an OT assessment or further input or reassessment for a child with a sensory processing disorder when it was previously available? I think that's probably too specific for me to answer now. What I can show you when we get to the regulations is the long list of professionals whom the local authority have to consult as part of the EHC needs assessment process. Can a parent insist on an extra year in specialist provision in the EHC plan? Well, if it's necessary provision to meet the child's special educational needs, then yes. And that's going to be something ultimately that the tribunal will be able to rule on. How long could an EOTAS package last for? As long as the child or young person remains in education. There's absolutely no legal limit to the provision that can be made otherwise than at school. I know what the question is getting at, because many local authorities seem to impose limits, 2 terms, for example. Very hard to understand what the legal basis is for any of that. Anyone in that position may well want to get some advice. A local authority hasn't provided the therapies in an EHC plan for 2 years and then removes the provision that hasn't previously been provided, i.e. takes the wording out. But again, not case-specific advice, but failure to actually do what's in the plan, the remedy is judicial review. Removing provision from the plan, well, that can only be done through an annual review, which then triggers the right to appeal to the tribunal. If the local authority tries to do it any other way, again, the remedy will be judicial review. Can a local authority or can a school have academic criteria? Yes, they can. But of course, if they're then named in the EHC plan, then that trumps everything else. So that's why, again, the EHC plans can be particularly important. Right, I think that's all I'm going to have time to answer now, because I'm conscious I've only got 10 minutes before the break. I'll have a look at any other questions that come in over the break. I was going to now talk in more detail about the appeal rights. So we can see that a child's parent or a young person may appeal to the tribunal against the matter set out in subsection 2, subject to the mediation requirement, which at the moment is only a requirement to consider mediation and get the mediation certificate, although there is a suggestion in the SEND review, the green paper, that may become mandatory, which I would have very significant concerns about, but it is, of course, only a proposal for consultation at the moment. So we see that the matters you can appeal about are, first of all, a decision not to assess, secondly, a decision not to issue a plan, and then thirdly, the contents of the plan in relation to the special educational needs, special educational provision, and placement. So those are the areas where there's mandatory obligations or an entitlement to appeal in a way that can trigger a mandatory order from the tribunal requiring amendments to the needs, the provision, or and the name of the school or type of school. People will be aware there's also now what was initially a pilot but is now entrenched, a power for the tribunal to make recommendations in relation to the health and social care sections of the EHC plans, but those are non-binding. They don't have to be followed, but the local authority or the CCG have to consider the recommendation. And if they're going to not follow it, they have to give reasons for refusing to do so, which could then potentially be challenged either through a complaint to the Ombudsman or judicial review. But in terms of formal appeal rights leading to binding orders, it's here in relation to special educational needs, special educational provision, and placement. So it may be necessary, of course, to appeal to the tribunal 3 times. Hopefully not, but it's conceivable that you'd have to appeal a refusal to assess, a refusal to issue a plan following assessment, and then the contents of the plan. You can also appeal against a decision not to reassess, a decision not to amend the plan following a review or a reassessment, or a decision to cease to maintain the plan. So every time there's an annual review, the local authority will send a new decision notice setting out either that they're not amending the plan, or that they are amending the plan, or they're ceasing to maintain the plan. Whatever decision they take, there's an opportunity for the parents or the young person to appeal to the tribunal, as we see here, following an amendment or replacement of the plan, as well as when it's first finalised. So that's the jurisdiction of the tribunal. What's important is that unless the tribunal has jurisdiction specifically given to it, it doesn't have any inherent jurisdiction of its own. And so in those situations, if there's not an appeal right, the remedy will be judicial review. The tribunal will not be available as an alternative remedy. A few other key duties before we leave the Act itself. very important point about the right to mainstream education. So we've seen already that there's the duties in section 39 to name the particular school chosen by the parent or young person if they choose one, subject to the exceptions. But there's also in section 33 for children and young people with EHC plans, a very high duty to ensure they get a mainstream education if that's what the family wants. So we see this section applies where the local authority is preparing the EHC plan. The local authority must secure that the plan provides for the child or young person to be educated in a maintained nursery school, mainstream school, or mainstream college, unless that is incompatible with the wishes of the child's parent or the young person. So, of course, if parents want or young people want a special school, they can have one, subject to considerations of cost. Or, and this is the only exception in cases where parents want mainstream education or young people want mainstream education, the provision of efficient education for others. And here it's expressly said the local authority may rely on the exception here in terms of provision of efficient education for others in relation to schools, colleges as a whole, only if it shows there are no reasonable steps that can be taken to prevent the incompatibility. And they can rely on it in relation to a specific school or college only if there's no reasonable steps that it or the school could take to prevent the incompatibility. So we can see in broad terms there's a very high onus. Parliament has placed a very significant emphasis on children and young people with EHC plans, and indeed without, attending mainstream schools or colleges if that's what is wanted by the family. And special or specialist, or perhaps more controversially, segregated education is reserved for cases where that's what the family want primarily, with a very, very narrow exception here where for that child to attend any mainstream school would cause such chaos that it would be incompatible with the provision of efficient education for others and nothing can be done about it. Would cause such chaos is gloss from me, but the upper tribunal and the High Court have repeatedly stressed how high that bar is. And it's very rare actually that local authorities even seek to argue it. I can think of 2 cases, I think, in my practice where I've had to meet that argument. It's very unusual that local authorities try to deny a child or young person the right to mainstream education if that's what they want. So that was section 33 that I wanted to pick out. As well as the appeal duty, appeal jurisdiction, we can then see there's lots of provisions here about mediation and dispute resolution, again, which I don't have time to go through. But what I did want to flag up is a couple of these duties here in the section 60s. So here we have the answer to that question about EOTAS, section 61, special educational provision otherwise than in schools and colleges, etc. A local authority may, so it's a power, arrange for any SEP that it's decided is necessary for a child or young person to be made otherwise than in school or college, but only, this is 2, if it's satisfied that it would be inappropriate for the provision to be made in a school or college. And before doing so, they've got to talk to the family. So there is a strong presumption that SEP in section F will be delivered in school or college. But if the local authority or the tribunal standing in its shoes is satisfied that this would be inappropriate, then it can be made anywhere else, including at home. And as we see, there's no time limit in relation to that. And there's also in section 63, quite an important duty here in relation to paying fees. So we'll see in 43, there's the duty to admit. Section 63 says if the local authority maintains a plan and provision is being made at a private school, essentially, or a non-maintained school, then the local authority has to meet fees, including board and lodging fees. So if there's any dispute about that, section 63 is the relevant provision. And I think, it says checking quickly, but there's nothing else in the Act that I absolutely have to draw to your attention in terms of explaining the basic scheme in relation to the EHC plan. That is true, but there is one other duty, there's always one more that I need to flag up, which is something I spend a lot more time on in the schools tool, section 66, because schools do not get a free pass in the legislation. They are told under section 66 that they have to use their best endeavours, which means do everything they can to secure the special educational provision that all of their pupils or students need, including those with EHC plans. But of course, for those with EHC plans, there's a higher level duty on the local authority actually to secure the provision. So the expectation is from Parliament that schools and local authorities will work together to make sure that needs are met and provision is actually made. Looking at some other final questions that have come in before we have our break. How can a special needs school argue that needs couldn't be met in their school? Well, if the child has a diagnosis that is outside of their designation, or if the nature and intensity of the child's needs are simply too great for them to meet them. Often, of course, what schools say is, oh, we can't have this child because the EHC plan specifies speech and language therapy. We don't have a speech and language therapist. But that clearly isn't right, because if the local authority have been ordered to or agreed to specify speech and language therapy in Section F, they then got to secure the provision. They then got to go and commission the speech and language therapy. So that would be a bad legal answer. But there are clearly answers that could be given, which may be correct as a matter of fact. Could you include wording in an EHC plan for a person supporting a child to be sat next to the child? Yes, clearly, if it's an appropriate specification of the provision, and that will be based on the expert evidence that's been received, generally from an educational psychologist. If a school no longer provides the provision in the most recent final plan because the local authority haven't updated it, does the responsibility lie with the school for not doing that provision, or does it lie with the local authority for not updating the plan? Both, I would say. Well, in fact, this is the local authority generally, isn't it? Because they've got to secure the provision in the old plan, and they've got to update and issue the new plan. But the school might be said to be in breach of the Section 66 duty in terms of not using the best endeavours to secure the special educational provision. But I would strongly say that in that scenario, the school and the parents should be working together to challenge the local authority, almost certainly through the judicial review pre-action protocol. And that leads me on to the next question, which is the only way that a school can hold the local authority accountable through judicial review? And the strict answer to that legally is yes. Judicial review is the legal remedy to challenge unlawful acts or proposed acts by public bodies. There are, of course, lots of other softer ways that schools and local authorities can, schools can seek to hold local authorities accountable, including politically, including through senior staff conversations. But as a lawyer, my answer to that is yes. Local schools, of course, can't appeal to the tribunal. There is the jurisdiction of the local government ombudsman to look at maladministration by local authorities. But if you've got straightforward unlawfulness, it seems to me that the more appropriate remedy will be judicial review. And I do quite frequently advise schools. So schools can take legal advice as to what their options are in that scenario. Could a school say that it will provide part of the provision outside of the school day and preschool learning only? I think that's a question where, again, people would need to take case-specific advice. It would very much depend on the wording of the EHC plan. Senko at a mainstream school said that a child would have to go to an SEN school if an EHC plan is in place. That's really concerning. Obviously, that's wrong. We've just seen how much the legislation places an emphasis on children with EHC plans going to mainstream schools. If Senkos are saying things like that, then there's obviously a major training issue. Thanks, everyone. There are lots of other questions which I will hopefully be able to answer as we go through the next part of the talk, because what I'm going to do next, after we had our break, is look at the regulations and the guidance which flesh out this scheme somewhat, for example, in terms of what exactly local authorities have to obtain by way of advice and information when deciding whether to issue an EHC plan or what the plan has to say. So we'll take a 15-minute break now. If everyone can come back at 11:25, we'll carry on for the final half of the session until 12:30. See you all then. Okay, hi everyone. Hope you're sufficiently refreshed and ready to go again for the next part of the talk, where I'm going to take us on to look at the regulations. So I will share my screen again. We've been looking at the Act. So regulations flesh out the detail that is found in the primary legislation and the secondary legislation. Regulations that we need, special educational needs and disability regulations from 2014. Again, we're looking for the legislation.gov.uk website to make sure that they're the official text. And these are the original versions of the regulations. I don't know if we have Good. Okay, there we go. Latest available. Great. So if you click on that button, you get the latest available, which is very important in case there have been amendments. We see there has been in relation to the coronavirus at some points. So in terms of assessment, we have in part 2 of the regulations these provisions in relation to the detail of the assessment duty. Regulation 3 requires consultation with parents and young people as soon as practical after receiving a request for an assessment. Regulation 4 fleshes out the detail about decisions where a local authority is going to refuse to assess, and also the requirement to notify various people of considering the question of whether or not to assess. The coronavirus exceptions, by the way, are all now repealed. They were in force during the height of the pandemic. And notification of the decision about whether or not to conduct an assessment here in Regulation 5, making sure that people are notified of their right to appeal, of course. And the time limit is only relaxed in very strictly limited situations, not at the moment relating to coronavirus. For example, child or young person are absent from the area. So it's very, very narrow, the reasons why a local authority can fail to comply with those time limits. This is a particularly important regulation, Regulation 6, because it gives you the detail of who a local authority has to seek advice and information from as part of the process of carrying out the EHC needs assessment. So at this stage, there's a decision to assess where the local authority secures an EHC needs assessment. It must, so it's a duty, seek the following advice and information. So that's what they have to be asking for. We'd like advice and information, please, on the needs of the child or young person, what provision might be required to meet such needs, and the outcomes. So it's need, provision, and outcomes, as you would expect. The first person that's got to be asked, understandably, is the family, the parent or the young person. They then have to take educational advice and information from, in short, the head teacher. Medical advice and information from, this is important, a healthcare professional identified by the responsible commissioning body, generally the CCG. So there isn't necessarily a requirement, for example, to have input from a paediatrician or an occupational therapist or whoever else it might be. It's got to be someone who's appropriately able to give medical advice and information, and that person is chosen by the CCG. Psychological advice and information from an EP. So Parliament or the Secretary of State here has decided that there must always be input, EP input into every EHC needs assessment. Advice and information in relation to social care. So almost always that will involve the local authority asking itself, i.e. the Education Department, asking the Children's Services Department for advice and information as to social care needs, provision and outcomes. It may be the case that the response that comes back is still, we don't know this child not known to social services. I think it's very clear that that's not a lawful response, taking into account the wider welfare obligations on the local authority under the Children Act 2004, for example. In order to safeguard and promote the welfare of the child, there needs to be a much more positive response, which should include offering a social care assessment to the family so that they can get to know the child or young person and provide advice and information on needs, provision and outcomes. Of course, you can't force the family to have an assessment. They may say, thanks very much, we don't want any social care input, in which case that's the end of it. But there should at least, in my view, be an offer to assess. Advice and information from any other person the local authority thinks is appropriate. So they've got quite a broad discretion there as to who to ask. If the child or young person is in or beyond year 9, they must obtain advice and information in relation to provision to assist the child or young person in preparing for adulthood and independent living. And this is very important, advice and information from any person the child's parent or young person reasonably requests that the local authority seek advice from. So if there are, for example, other health professionals involved, then the parent or the young person can request that the advice and information is sought from them. And as long as that's a reasonable request, the local authority must do so. There's then specific requirements in relation to children who are hearing impaired or visually impaired. And if advice and information is to be sought, then that person must be provided with representations made by the parent or young person and any evidence submitted by them. And the only time in which the local authority mustn't do this is if everyone, including the parent or the young person, agrees that it's not necessary, satisfied that what they've already got is sufficient for the purpose of the EHC needs assessment. And it would be quite unusual, I'd suggest, that the family would agree to that, because part of the purpose of an EHC needs assessment is to gather up-to-date advice and information. So Regulation 6 is very important in terms of the detail of what's required to be obtained during the EHC needs assessment process. This is what the local authority must do in securing the EHC needs assessment: consultation with the family, consider any information they've provided, engage the child and parent, and ensure they're able to participate in decisions and minimise disruption for them. And then in Regulation 8, we have this important duty to cooperate in the process. So where the local authority requests the cooperation of a body in doing the EHC needs assessment, they must comply with the request within 6 weeks, unless, again, one of these very narrow exceptions apply, not currently including the coronavirus exception. So that's the scheme in relation to EHC needs assessment. Then we have the requirement in terms of provision of advice and information and support to parents in the EHC needs assessment process in Regulation 9. And finally, in terms of the decision not to issue a plan, if that's the decision at the end of the EHC needs assessment, then lots of specific procedural requirements imposed here, including, again, the requirement to notify the family of their right of appeal. So that then takes us on to EHC plans. Regulation 11 says that in preparing the plan, the local authority must take into account the evidence obtained through the needs assessment, obviously, and how best to achieve the outcomes to be sought for the child or young person. Regulation 12, very importantly, specifies the form of an EHC plan. So at the moment, people will be aware there is no national mandated template for an EHC plan. The requirement is that the plan must set out the following things in the following sections. But it is, it would seem, lawful, for example, for some of these sections to be combined, or for the order of the sections to vary. So as long as the relevant sections are there, exactly how the local authority sets it out is a matter for it, but they must cover these things under the relevant headings. So Section A, in terms of aspirations, is non-enforceable background, essentially. Section B then is educational needs, special educational needs. C is healthcare needs relating to SCN, which essentially is additional healthcare needs, I suggest. Section D, social care needs relating to SCN or to a disability. And then E, the outcomes across those three areas. F, SCP. G, healthcare provision reasonably required by the learning difficulties or disabilities which result in the child or young person having SCN. Not ideal as a form of wording, but often again just simply understood as being about additional healthcare provision. Social care is then a mess. So Section H1 is social care provision that must be made under Section 2 of the CSDPA. So that's the provision that there is a duty, a specific duty to make on the local authority for a child, essentially up to 18, so some young people as well, young people are those over 16 in this scheme. And then H2 is anything else, which will be everything for an adult under the Care Act. So for children, it's really important that provision is included in Section H1, in the sense that if it's not in H1, if it's in H2, it may be argued that the local authority doesn't have to actually make it. But in fact, this scheme doesn't change anything in terms of the underpinning duties in relation to social care. It's still very much, it's just very much a record of what has to be done under the Children Act and the CSDPA for children, under the Care Act for adults. Section I is then the name of the school, etc., that's going to be, the child's going to attend, or the type of school, where no particular school is identified yet. And then Section J is related to direct payments. And each section must be separately identified. But that hasn't yet been understood, at least, to mean that the sections can't be presented together. Healthcare provision has to be agreed by the CCG, and if the child or young person is in or beyond year 9, the plan must include provision to assist them in preparation for adulthood and independent living. And the advice and information has to be set out in the appendices, and that's then called Section K. So it's Regulation 12 that describes and prescribes the form of EHC plans. Timescales for EHC plans. So this is very important. So where a local authority sends a draft plan, it must give 15 days for responses. And then the ultimate time frame is 20 weeks. So from the date that the request for the EHC needs assessment has been received, the final plan must be issued within 20 weeks, unless one of the limited exceptions apply. And that is a mandatory legal duty. The fact that something's in regulations makes zero difference in terms of its legal enforceability. It's equally enforceable as if it was in primary legislation. So I'm just going to close my email. This isn't anything, unfortunately. So it's very important that that is followed, and a failure to follow it is as amenable to judicial review as any other kind of breach of statutory duty. The fact that many local authorities sadly fail to meet that time frame doesn't make it any more lawful for them to fail to do so. The final plan then has to be sent out in accordance with Regulation 14, again with the right of appeal if people are unhappy with the contents. Transfer of plans, for those that are concerned, essentially the way the scheme works is that the plan moves from the old authority to the new authority, but the new authority can then start again and of course issue its own EHC plan in accordance with Regulation 15. So they're not bound by it. Similar provisions in relation to CCGs under Regulation 16. And then some other specific provisions that I don't think we need to dwell on at the moment. Reviews and reassessments. This is the set of regulations that were considered recently by the High Court in the Devon case, where the court held that there was in fact a specific time frame within which the annual review must be completed and a final EHC plan published, because there isn't a gap in the middle where local authorities just have to act reasonably. And that time frame is essentially 12 weeks. So unsurprisingly, perhaps, given that it's a duty to review every 52 weeks, there is a limit by which the local authority have to then issue any amended plan, or of course, the decision not to amend. Regulations in relation to ceasing to maintain an EHC plan are here, if anyone's concerned with that particular scenario. Detail in relation to mediation, set out here. And then powers of the first tier tribunal. So we can see that what the tribunal can do if you appeal is you dismiss the appeal, of course, order the local authority to assess, order a plan to be made, maintained, refer back to the local authority, very, very unusual that they do that, order the local authority to continue to maintain the plan, either as it was or amended if the tribunal thinks it needs to be updated, change the school or institution in the plan. So very extensive powers. And what's important is that the tribunal isn't exercising some kind of judicial review jurisdiction where it's looking at whether the local authority has made a lawful decision. The tribunal actually decides for itself what's needed. And so the local authority and the parents are essentially in equal position because they have to put forward evidence to support their case that X provision is needed or not, that school Y is the appropriate school, and so on. So it's a much more intrusive kind of review by the tribunal than you'd get in the High Court on judicial review. The tribunal, therefore, is a very important legal safeguard for parents and young people. Duties in relation to SENCOs set out in the regulations here as well. The requirements as to a local offer here in Part 4, and then some important provisions in relation to capacity, as in the ability to make decisions for yourself. And to take that shortly, how the scheme works here is that if a young person aged over 16 who has an EHC plan or may have one is able to make their own decisions, they can do so and, for example, bring an appeal in their own name. But if they can't, if they lack capacity under the Mental Capacity Act, then the parents automatically have the right to continue to do so for them, assuming they have capacity, unless there is a deputy appointed by the Court of Protection or someone with lasting power of attorney. So instead of a kind of best interest decision-making process that you'd have in other areas, in this case, the parents just get to carry on making the decisions for the child or young person. So that's my whistle-stop tour through the SEND regulations, picking out those that I think are particularly important. I'm just going to now go back to the Q&A and see if there's any other questions that I need to answer at this stage. Can section J, in terms of direct payments be added during an annual update? Yes, an annual review, absolutely, it can be. Any deficiencies in an EHC plan can be corrected and should be corrected at each annual review. Does the 20-week time frame include time during school holidays? Pretty sure the answer to that one is yes. I'm going to go back and look at the law though, because one of the great advantages of doing this live is I can check. So if we look at the exceptions in Regulation 13 here, it refers back, doesn't it, to the exceptions in Regulation 10. So I'm just going to go and look at those. So if the school, they don't have to comply with the time limit if it's impractical to do so because the local authorities requested advice from the head teacher or principal of the school during a period beginning 1 week before any date on which that school or institution was closed for a continuous period of not less than 4 weeks from that date and ending 1 week before. It's a bit convoluted, but essentially the summer holidays, right? Because no other holidays last for at least 4 weeks. So there's an exception that might be relevant there. The authorities requested advice from the person, similar, exactly the same for early years as well, the 4-week closure. Exceptional personal circumstances affect the child or the child parent or the young person, that's not going to be relevant. Or they're absent. So I suppose if the family were absent for 4 weeks because of a holiday, but again, that will only be the summer holidays. So the short answer to the question is only the summer holidays. And even then, the exception is only, it's not a blanket exception, it's only if they can't do it because of that thing. So they have to explain why not and do it as quickly as possible thereafter. Should the number of hours of support, agreed by the local authority when the EHCP is issued be stated somewhere in the EHC plan? Yes, definitely. So we'll see in a moment when we get to the code of practice that it's really important that section F is quantified and specified. So the number of hours of support would be quantification, because if the EHC plan simply says that the child will have opportunities for small group working, then as long as they get to do it every now or then, there's been compliance. If it says the child will work in a small group for at least 2 hours a week, then it has to be done for 2 hours a week. So it's very important that there's appropriate quantification and specification. And obviously that needs to be based on evidence. If you've got an annual review that's been held a long time ago, let's say, and the local authority still hasn't provided its decision, is judicial review the only way to get to the appealable decision? And I'm afraid the answer to that is yes. So for example, SOS SEN, the charity, they have a low-cost service where they'll send pre-action letters on behalf of families. And to explain what that is, if you're going to use judicial review, you have to write first to the local authority and explain why they're acting unlawfully. So it's a stage in the process before you go to court. So the charity SOS SEN offers that low-cost service precisely because, sadly, it's often necessary to send a pre-action letter just to get a decision that you can then appeal. Very difficult, obviously. What's the difference between the regulations and the code of practice? Great question. So the regulations are law. Whether something is in the Act or the regulations makes no difference. It's law, and if it says must, it has to be done. The code of practice is only guidance. And I should have shown you actually. I'll do it now. Hopefully you can still see my screen. If we go back to the Children and Families Act. And look at section 77. That's the provision which requires a code of practice to be issued. So the Secretary of State must issue a code of practice, giving guidance about the exercise of their functions under this part. So that's what the code does. It gives guidance about how these people, lots of people, should exercise their functions under the Children and Families Act. And those persons listed must have regard to the code. So the legal status of the guidance is that it's have regard guidance, which means it has to be considered, has to be taken into account, but it doesn't have to be followed. So where the code of practice says must, that's where the civil servants who wrote it think the law requires something. And they're generally right, but they may occasionally be wrong. So the best thing to do, I'd suggest, is to look at the regulations and the Act themselves, if you can, rather than necessarily just going on what the code of practice says, because the law says what it says, and the code is merely guidance. Really interesting question. Can parents put in what they want to any section of an EHC plan during an annual review, or do the sections B onwards, i.e. the substantive sections, need to be evidenced by the relevant professionals? Well, parents can certainly ask for provision to be included in the EHC plan based on their own view as to what their child needs, and what the needs are, what the provision would be, etc. The sad reality, I think, is that despite all of the focus on parents as partners, parental expertise, and so on, certainly at the tribunal, you need professional evidence to substantiate that something is a need, or that there is provision that's necessary to meet a particular need. And the fact that parents say it, I'm afraid, is unlikely to be given enough weight to be decisive. There's no harm, of course, in the parents asking, even if what they think is correct is not necessarily supported by, quotes, expert evidence. So just to clarify my point about hours, where a local authority agreed a number of funded hours, should that be specified in the EHC plan in section F? Well, I would strongly say, again, generally, yes, because of course, if it's in section F, it has to be secured. If it's not in section F, then you've got to rely on much looser legal duties, like the concept of a legitimate expectation because something's been promised. But why wouldn't it instead just be included in the EHC plan so it's nailed down? Some questions, I'm afraid, that are going beyond the scope of the talk today. So if I'm not answering, and it's not a specific question about EHC plans, please forgive me, but I'm concerned that we're not going to have time. An interesting and important question about legal aid. Legal aid doesn't usually cover legal representation of the tribunal unless there are exceptional circumstances. Would the parent being autistic and struggling with the process be considered exceptional? I would strongly suggest yes, it would. So there's something called exceptional case funding, ECF, which is available, where solicitors who've got the right contract with the legal aid agency can ask for funding for representation, which will allow them to instruct a barrister to attend the hearing itself. However, I would also point out that lots of junior barristers will do pro bono representation in hearings as part of building their practice. And if a parent has a solicitor on legal help, they should be able to get pro bono representation from either a pupil trainee barrister or from a junior if they contact chambers like mine and a number of others that do lots of work in this area. So yes, it's possible to get legal aid for representation, but it should also be possible to get free representation if you've got a solicitor that can then instruct the barrister. The problem, of course, is that very few junior barristers are able to take direct access instructions. Most of them will need to be instructed by a solicitor. So you need to get the legal aid to get a solicitor, or potentially pay privately for a solicitor if you're in a position to do so. Okay, so I'll move on now then, just quickly via the personal budget regulations, as I mentioned, just to show you where they are. So if you're concerned about this particular area, you've got, that's the draft, sorry, I'm just trying to find the final page. It's slightly, well, again, the draft only, gosh, they not actually put the final version online. Let's see. Oh, here we are. Good, right. So these are the provisions in relation to personal budgets and when a direct payment has to be made and when it doesn't have to be made. Just for reasons of time, I'm not going to be able to go through that now, but the answer to many of your detailed questions about personal budgets are going to be found in these regulations, although look, they haven't actually updated them, so there may be a few amendments pending, but at least the basic scheme is going to be there for you to consider. Let me go now to the code of practice. We do need to consider the code. Of course, it's pretty out of date now, sadly, and one of the things that will happen, I'm sure, as a result of this end review is there will be a updated code of practice, but there are still some very important points of guidance within it. And it is, of course, guidance on the whole of the scheme, not just on EHC plans, but there is a section of the code on EHC plans that we need to spend a little bit of time on. So we can see the various chapters going through, covering early years providers, schools, and further education, preparation for adulthood. And then at the end, quite rightly, because of course we've got all the SEN support stuff first, we get EHC needs assessments and plans. And we see what legislation we're looking at here. We've looked at sections 36 to 50 of the Children and Families Act, the whole of the Care Act, the CSDPA and Children Act for Children's Social Care, and then the two sets of regulations that we just looked at. with a few other regulations bundled in as well. We see some useful guidance here about the purpose of an EHC plan. The purpose of an EHC plan is to make special educational provision to meet the special educational needs of the child or young person. So again, a very clear emphasis on education being the primary consideration here. And then to secure the best possible outcomes for them across education, health and social care, which is interesting. Well, why not then have equivalent duties on health and social care? That's a matter for Parliament. And as they get older, prepare them for that. To achieve this, local authorities use the information from the assessment to provide a full description, that's quite important, of the child or young person's special educational needs and any health or social care needs. So the case law makes clear that the EHC plan has to include each and every one of the child's special educational needs, and that's summarised here as being a full description. Establish outcomes based on needs and aspirations, specify, first use of that term, the provision required, and how education, health and care services will work together to meet the outcomes. We know what the threshold is for the assessment. We're going to see the factors that the code says should be taken into account in a moment. Here are paragraphs 9.14 to 15. The EHC needs assessment should not normally be the first step in the process. Rather, it should follow on from planning already undertaken in conjunction with the school or setting. In a very small minority of cases, now do bear in mind that's guidance, that's not some kind of legal test. So who knows how small that minority really is. Children or young people may demonstrate such significant difficulties that a school or provider may consider it impossible or inappropriate to carry out a school chosen assessment procedure. Quite why that means that, quite why it's suggested there needs to have been a full chosen assessment procedure by a school, I'm not entirely sure, because of course we know that the duty to assess is on the local authority. Don't worry about the transition to the new system, we're there already. EHC plans should be forward-looking documents to help raise aspirations and outline the provision required to meet assessed needs. EHC plan should specify how services will be delivered as part of a whole package. Again, another use of that key term. We know that an EHC needs assessment always lead to an EHC plan. The statutory process and timescale set out in this chapter must be followed. Yes, they must, absolutely. The section 36, duties in relation to EHC needs assessment. I think we've explored that fairly thoroughly. Considering whether an EHC needs assessment is necessary, section 36 plus regulations 3 to 5. Again, we've looked at that in quite a lot of detail already, so I don't think we need to spend any more time on that. Save for this point here at 9.14. In considering whether an EHC needs assessment is necessary, the local authority should consider whether there is evidence that despite the setting having taken relevant and purposeful action to identify, assess and meet the needs, the child or young person has not made expected progress. So a few points about that. One is, this is not law, this is guidance. So that should is what the Secretary of State would like you to do this, but Parliament, or indeed the Secretary of State through the regulations, hasn't mandated it. So it's not part of the test, it's merely guidance as to how to apply the test. Secondly, what happens if the school or setting hasn't taken relevant and purposeful action? Does that mean that in that context, the local authority can just say no? I would strongly say no, it doesn't, because the focus must be on the welfare of the child, and incompetence on the part of the school or setting cannot be a reason to avoid the duty to carry out an EHC needs assessment. And then to inform the decision, the local authority will need to take into account a wide range of evidence and should pay particular attention to, again, this is guidance, evidence of academic attainment and rates of progress, information about the nature and extent and context of the SCN, evidence of action already being taken, so my point about the school's letter of support often being very helpful, evidence that where progress has been made, it's only been as a result of much additional intervention and support, evidence of needs from other areas, and additional time to complete education for those over 18. A local authorities may develop criteria as guidelines, importantly, to help them decide when it's necessary to carry out an EHC needs assessment. However, local authorities must be prepared to depart from those where there's a compelling reason to do so, must not apply blanket policies, obviously. And they've got 6 weeks to make the decision. Then there's some guidance on principles underpinning coordinated assessment and planning. We haven't looked at the section 19 duties in terms of involvement of children and young people, but those are, of course, fundamental to all parts of the process, and any complaint about failure to properly engage children, young people and families will want to refer to this part of the guidance. Support that must be provided to children, young people and parents through the SENDIAS service, essentially. Coordination of the process. Local authorities are responsible for ensuring there's effective coordination. That's a theme we're going to keep going back to. It's not the school's job, it's the local authority's job. Information sharing, as far as possible, there should be a tell us once approach. Timely provision of services. This is quite important. Provision should be delivered in line with relevant statutory guidance and should not be delayed until the EHC plan is complete. So it's not a question of the local authority gets 20 weeks before it can do anything. There should be provision as soon as a need is identified, certainly in relation to social care. And I would suggest the same in relation to education and health as well. Cross-agency working, specific consideration of looked after children, particularly aware of the need to avoid any delays for looked after children, carry out those assessments in the shortest possible timescales. And then we get on to the timescales. The time limits set out below are the maximum time allowed. Steps must be completed as soon as practical, very important. The whole process must take no more than 20 weeks, and we've looked at the exceptions already. And this very helpful diagram here goes through the different stages of the process, what needs to be done within what time frame. But the key I would suggest is this right arrow down the side, that the whole thing must take no more than 20 weeks. So even if certain stages slip, the overall process must be completed within 20 weeks. That's the bottom line. Here's the guidance on advice and information. We've looked at the detail of those regulations, so I won't spend any more time on that now. Decision on whether to issue an EHC plan. So where in the light of the EHC needs is something that's necessary for special educational provision to be made, the local authority must prepare a plan. That's the law, and that's why the word there is must is involved. In deciding whether to make special educational provision, consider all the information we know from the assessment. And then what's suggested to be a key question is here: despite appropriate assessment and provision, the child or young person is not progressing or not progressing sufficiently well. But of course, again, what happens if appropriate assessment and provision hasn't been made? Again, that can't be an absolute reason for the local authority not to issue the EHC plan. What to do if you're deciding not to issue? We've looked at that. Transparent and consistent decision making, moderating groups to support transparency, writing the EHC plan. So this is really important. The contents of the EHC plan itself. The following principles and requirements apply to local authorities and those contributing to the preparation of an EHC plan. Decisions should be made openly and collaboratively, parents, children, and young people. EHC plans should describe positively what the child or young person can do and has achieved. And that's quite interesting because there's no section of an EHC plan that says that. And if you go to the tribunal, often some judges at least will say, well, I'm afraid we're not interested in strengths, Mr. Broach. We want to hear about the child's needs because that's what the legislation requires. So it's not actually, the guidance doesn't tell us where the positive description, but very often what you'll see is within the subsections of the needs, there'll be a section for strengths before the needs are then described. Having said that, the EHC plan should be clear, concise, understandable, and accessible. Not sure how many EHC plans meet that standard, frankly. They should be written so they can be understood by professionals in any local authority. We know they must consider how best to achieve the outcomes and take account of the evidence. EHC plans must specify the outcomes sought, and outcomes should be smart, specific, measurable, achievable, realistic, and time-bound. We'll go on to look at that in more detail in just a moment. Specific provisions in relation to personal budgets, coordination, forward-looking. So EHC plans should anticipate, plan, and commission for important transition points. So not just describing the next few weeks, but at least the next year, of course, prior to the next annual review, including formal as well as formal support. But it's very clear that you can't include family provision in Section F. You can't put a duty on the family or indeed the young person themselves to make provision and have a review date. The format of an EHC plan will be agreed locally. So it was expressly intended that there will be local variation, despite that now being said to be a problem in the SEND review. but they must, as a minimum, include the following sections, which must be separately labelled, as we know. The sections do not have to be in the order below, and they may use an action plan in tabular format. So that's how we get to those variations in approach. Outcomes. So this is quite important in terms of what is an outcome and what the difference is between an outcome and an aspiration. So long-term aspirations are not outcomes in themselves. Aspirations must be in section A. A local authority cannot be held accountable for the aspirations of a child or young person. So the outcomes, and I've cited this numerous times, 9.66, an outcome can be defined as the benefit or difference made to an individual as a result of an intervention. So an outcome is not that Johnny will receive speech and language therapy. An outcome is that Johnny will be able to communicate more effectively. But that outcome isn't SMART. So we want it to be specific, measurable, achievable, realistic, and time bound. So it might be that within 1 year, Johnny will be able to use a sentence of 4 words, for example. And whatever it is that the professionals say would be an appropriate outcome in that particular case. So it should be personal, not expressed from a service perspective. Specific, measurable, achievable, realistic, and time bound. Where it's focused on educational training, it will describe what the expected benefit will be to the individual as a result of the educational or training intervention. Not a description of the service being provided. So there's my speech and language therapy example. Outcomes underpin and inform the detail of the EHCP plans. They will usually set out what needs to be achieved by the end of a phase or stage of education. From year 9 onwards, the nature of the outcomes will reflect the need to ensure they're preparing for adulthood. And then there should also be shorter-term targets at the level of school or other institutions, so there can be staging posts on the way to a particular outcome. So between 9.66 and 9.69, the code gives us the guidance we need to make sure that outcomes can be described effectively. And then this table is perhaps the bit of the code of practice I refer to more than any other, what to include in each section of the EHC plan. So section A, as I say, I'm afraid as a lawyer, I'm not particularly interested in section A because it has no legal effect. It may well be useful for practitioners. Section B then, and this is important, all of the child or young persons identified special educational needs must be specified. And then we have the reference 21.5 about the deeming provision in terms of educational training. Then at C, health needs, any health needs identified through the assessment which relate to the SEN, don't include routine dental health needs, for example. Social care needs, anything that relates to the SEN or disability. Could include reference to any child or need or child protection plan, but not necessarily, because inclusion must only be with the consent of the child and the parents. And then the guidance on outcomes. So there should be a range of outcomes in section E over varying timescales, covering education, health and care as appropriate, recognising it's the education and training outcomes only that will help determine when a plan is seized for young people aged over 18. So that's really important that the outcomes for education training are right in terms of allowing the plan to continue as long as it really is needed. Clear distinction between outcomes and provision, very importantly. Steps towards meeting the outcomes, monitoring, forward plans, and so on. And then this is the bit I quote most of all, section F. The provision must be detailed and specific. The duty there is a duty of specification and should normally be quantified. And that's again reflects the case law, for example, in terms of the type, hours, and frequency of support and level of expertise. So those are the usual forms of specification and quantification that we would expect to see. Provision must be specified for each and every need specified in section B. So it should be possible to understand what provision is meeting which needs. And it should be clear how the provision will support achievement of the outcomes as well. But the duty is to have provision that meets needs. So the link is between sections B and F in this case. Where health or social care provision educates or trains a child or young person, it must appear in this section. So it becomes special educational provision because of section 21, subsection 5. If a local authority is going to depart from advice, it should say so and give reasons for doing so. Never see that, frankly. And then specification of appropriate facilities and equipment, staffing arrangements, curriculum, modifications to the national curriculum, exclusions to the national curriculum, if a residential provision is going to be made, etc. In section G, similar for health, provision should be detailed and specific and should normally be quantified. The upper tribunal has suggested there's a lesser duty to specify and quantify in relation to health provision. I'm not convinced that will be followed in other cases, but certainly that's the current state of the law. That the health and social care provision may be less specified and quantified than the educational provision, but there's still an expectation, there's still a should here in terms of specification and quantification for health and social care provision as well. And then placement, the name and title of the school. In fact, that's not necessarily correct, because if it's just going to be the school, the name of the school is sufficient, I would suggest. But only in the final plan, of course. So there we go. Now I won't go through the rest of this section, just for reasons of time. I wanted to show you in particular the guidance on outcomes and that table. And I can see there are lots more questions coming in on the Q&A. So I'll go back to the Q&A now and then see how much more time we have left at the end. So a question, how do you define the difference between section F and section G? Which takes me directly back to the table, very helpful. So section F is all the provision that's meeting educational needs. It says here very clearly, the special educational provision required by the child or young person. So that's anything that educates or trains. And then section G is any healthcare provision reasonably required by learning difficulties or disabilities that result in SEN. So any additional health provision from a specialist that would not normally be available to a typically developing child, but which is not educating or training, should go in section G. I know that's slightly convoluted, but I hope that can be made to make sense in practice. Toileting, so toileting is F rather than G, even if it's from nursing or NHS. I would say probably yes, because if the purpose of the intervention is to educate or train the child or young person, then it will be educational provision. It doesn't matter who's funding or commissioning or providing it. It just matters what the effect is. So there's a case that says that a powered wheelchair is capable of being special educational provision if the effect of having that wheelchair isn't just so that the child gets from A to B, but that they learn better how to maneuver in the environment, for example. So if it is educating or training them, then it is educational provision. Can you appeal section E? No, not directly. So the outcomes are not appealable, but what the upper tribunal has said is that because there's a jurisdiction to make consequential amendments, then the tribunal can make orders in relation to section E if it thinks it's necessary to do so to amend the outcomes to reflect the new special educational provision that it's ordering. But not all judges seem to agree they have that jurisdiction. So be prepared to have an argument about that. If you go to the tribunal, you may not find a willing audience for that argument. Can strengths be put in the child's story, the child's views in section A? Yes, they can. But I have to say, my experience is that very few people actually read section A of an EHC plan. So I'm not sure how much value there will be in putting anything, sadly, in section A. Perhaps I'm being too cynical. Sections E and F of an EHC plan, what happens if it looks like they're just cut and paste from an expert report? Well, it depends what the expert report says and if it's any good. It may be, but actually that's a very good thing, because of course local authorities are supposed to base their decisions on the evidence, but very few EPs draft their reports to be cut and paste into a plan. So that certainly would be a concerning approach, I would suggest. Does a local authority have a duty to monitor? Sorry, I'm just losing my questions, 1 second. Here we are. Does the local authority have a duty to monitor the contents of the EHC plan? Yes, absolutely, because as we saw, section 42 imposes the duty on the local authority to secure the provision. So the local authority has to know whether its plan is being delivered. It's not acceptable for a local authority to simply say, right, school, over to you. Of course, the local authority can expect the school, particularly a school that it's funding, to make the provision. But if it doesn't do that, the legal remedy is going to be against the local authority. So very much the local authority must monitor. Is it down to the parents to know and raise concerns? I'm afraid probably yes, it is, or the school, if they think they're not being properly resourced. Some local authorities don't include short-term outcomes, only long-term. Well, we've seen the guidance says very clearly in relation to section E, it says, going back to it so I don't misquote it, that a range of outcomes over varying timescales should be included. So it is only guidance, but it's guidance they have to have regard to. And that would generally suggest that if they're not going to do that, they would need to explain why. So it's certainly something you can push back on, I would suggest. Should all reports be given to parents and carers before an annual review meeting? Yes, absolutely. How do you challenge them if they don't? I'm afraid, as ridiculous as it might sound, you'd have to send them a pre-action letter under the judicial review protocol if you're going to formally, legally challenge. Of course, it may be that that's an issue that you can deal with by way of a complaint. But certainly, in order for the annual review meeting to be effective, parents need to be able to comment on the evidence, of course. Can you appeal Section F of the EHCP plan? Very much so. So one of the largest reasons to go to the tribunal will be because you want additional provision in Section F of the plan, more speech and language therapy, for example, additional one-to-one support, whatever it might be. And so sometimes parents will only appeal Sections B and F because they're happy with the placement, but they want more provision. Very unusual you'd only appeal F because it's likely that if there's flaws in the provision, the plan won't also describe the needs effectively. And certainly even more unlikely as a parent, you'd ever want to only appeal I. So you would not want to just say they've got the school wrong, because you'd also want to say that the reason they've got the school wrong is that they haven't identified the needs fully and they haven't identified all the provision that's required. Otherwise, if you're accepting the need and the provision, then it seems unlikely the local authority will have named a school that's inappropriate. Not impossible, but far less likely than if you're challenging the needs and the provision as well. Can parents request a provision map on how an EHCP funding has been spent? Well, the formal request, of course, would be for a personal budget, which may end up looking like a provision map. But we've seen the entitlement to a personal budget, i.e. a description of what the resources are that have been allocated to delivering the provision. Can counselling be included in an EHC plan? Well, definitely, but the question is, where would it go? So is the counselling a form of education or training? Possibly. It will all depend on whether it's decided on the evidence that that counselling is amounts to educational training, that its effect is to educate or train the child. So, as always, the legal test is quite easy to state, harder to answer in practice, but it needs to be answered on the evidence. If it's not, if counselling is an educational provision, then it will almost certainly be health provision, or I suppose conceivably be social care. What case law is helpful to understand challenges to local authorities? Well, one of the things that I've done is work with the Council for Disabled Children on a case law directory. So it's slightly out of date at the moment. We're working on updating with the most recent summaries at the moment, but there is, I think, still very helpful resources on here. And you can see it's broken down by areas of law, including one on the EHC plans, split discrimination claims against schools, etc. So you can have, sorry, I think I clicked on the quality by mistake there. Let's try EHC plans. Yeah, there we go. Level of specificity in Section F, entitlements to lawyers to attend mediation, when it's necessary to make an EHC plan, etc., etc. So if you're interested, there's lots of case law summarised on the CDC website. And the CDC website also includes, happily, text of our book, so Disabled Children, a Legal Handbook, by the hard copy or the ebook from Legal Action Group. That's the third edition there. And so you can buy it by the hard copy or download it. With myself and Luke Clements. Luke's looking very moody there, and I'm looking a bit thinner. It's pre-pandemic. Or you can actually access pretty much the whole thing, and certainly in terms of the full chapters on the CDC website free of charge. So you can download each of the substantive chapters of the book. So, for example, for today's purposes, the education chapter, which will tell you, amongst other things, all about EHC plans, EHC needs assessments, EHC plans. So that resource is available free of charge, as is the case law directory. Or if you're able to, you can buy the hard copy or the ebook of the text itself. Thanks for the opportunity to give that plug there. Coming back to some other more specific questions, have we seen specialist driving lessons being named in the EHC plan? Yes, I have. specifically. So the answer to that one is yes, I have, as educational provision. Can you use your child's DLA assessment in your EHC plan? Well, you can certainly use the evidence from an assessment for disability living allowance, in the sense that as parents, you can put forward anything you like. So no reason not to do that, but it's a matter then of how relevant that evidence is going to be for the particular issues that you're looking at there. What happens if a needs assessment's been agreed, but the issuing of an EHC plan takes longer than 20 weeks? I think I'm starting to sound like a stuck record here, aren't I? Because the answer is judicial review. And as I said earlier, that's a scenario where charities like SOS, SCN, and some of the legal aid solicitors as well will offer low-cost services of sending pre-action letters to say, you've got to issue the plan, you haven't issued it, that's unlawful, because it's an extremely straightforward kind of claim. Go back a little bit, because I think there's some questions that I may have missed from earlier on. So when a tribunal says that one-to-one or any other form of support is needed on the EHC plan, can the local authority remove this? Well, yes, they can at the annual review. See, there's nothing, this is quite important, the tribunal doesn't set in stone that any kind of provision is going to be needed forevermore. The local authority can review and say, no, we think it's not necessary. But of course, the parents can then appeal to the tribunal again, and you can, and on it can go. So I'm afraid that for reasons that make sense, EHC plans don't provide any kind of lifetime guarantee. Should the EHC plan be progressive, looking towards the future? Yes, absolutely. We've seen that in the Code of Practice expressly stated. What about when you've got conflicting EP reports? So that's very interesting. Well, the local authority's EP says one thing and the independent says another. Yes, it's for the tribunal in that scenario to decide which evidence they prefer. And very often, tribunal appeals will come down to whose EP the tribunal thinks is giving the best quality of evidence. Often that will be the independent EP, because it seems that local authority EPs are under a huge amount of pressure, and often the reports they put in are very thin. Doesn't necessarily, it's not that the tribunal weighs the evidence literally, but they will give more weight, or should give more weight, to evidence that is more detailed, more thorough, based on a more extensive understanding of the child's needs. So it's not about who employs the person or who's paying them. It's about who they are, their qualifications, their experience and expertise, and fundamentally the quality of the evidence that they produce. Yes, I think it's interesting, actually, several questions about extending education and retaking years. Certainly that is additional provision, isn't it? It's educational provision that's additional to or different from that which other children get. So I see no reason why that shouldn't be possible within an EHC plan. A question that's beyond my expertise, I'm afraid. What are the generic pros and cons of sixth form versus college for an SCN child? I'm very conscious that I'm a lawyer, not an educational practitioner, so I'm not going to be able to answer that one, I'm afraid. So questions about the tribunal and a particular scenario in relation to speech and language therapy provision. How can you first of all try and avoid the need to go to tribunal? Well, get the best quality evidence you can as quickly as you can and make sure the local authority has it. And so in this case, obviously, that would be an independent speech and language therapy report. If the NHS provision locally isn't sufficient, is the local authority obliged to find a provider who can deliver it? Yes, they are, absolutely, but only if you've established that there is a requirement to have the therapy in the first place. And if the case does go to tribunal, who's liable for the cost? Well, each party will have to bear their own costs, unless you're one of the vanishingly small number of cases where the tribunal decides that someone's acted unreasonably. And I'm talking literally handfuls of cases ever, as I understand it, where cost orders have been made. It's very, very unusual. It's supposed to be what's described as a cost-neutral jurisdiction. And of course, it's not expected that parties will have legal representation. Very often local authorities will have legal representation, and parents often choose to as well, but it's not intended to be necessary. Do you have to have a lawyer to go to tribunal? Absolutely not. If you've only got the money to pay for an expert or for a lawyer, who should you pay for? Almost certainly the expert, because lawyers can't do anything without evidence. Is it better to have your case represented by a lawyer? Depends which one it is, depends if they're any good. But I do think very often complex issues come up, either of fact and or of law. And certainly in appeals about contents of plans or appeals that concern placement, it may well be advantageous to have representation if it can be obtained and if it can be funded. So it's certainly not essential, but my view is if you can do it, it will be better to do so. And I've certainly acted for quite a lot of lawyers who themselves have children with SEN, who have chosen to instruct a specialist lawyer rather than do it themselves, which I think is quite compelling evidence that it's a challenging thing for parents to be expected to do unsupported. Just going back up. Can you ensure that the child doesn't receive a particular kind of provision? Yes, in the sense that the plan can specify what they have to receive. And so if a certain therapy or intervention is indicated in the plan and it's supposed to happen full time, that therefore necessarily means that nothing else can be used. So you can achieve the outcome of not getting something through the positive course of specifying what must be done. Is the local authority legally required to attend an annual review meeting? No, but the code of practice is very clear that they should generally attend annual review meetings, but they don't have to. And at the end of the day, the school's obligation or the setting is to facilitate the meeting. And then the local authority's obligation, of course, is to actually amend the plan based on the evidence that's obtained from the meeting. So the annual review isn't the meeting. That's quite important. The annual review, of course, is the process by which the local authority decides whether to change the plan or not, or indeed whether it should continue to be maintained. The meeting is one stage in that process. The child has a diagnosis but is progressing well. Does it mean they don't qualify for an EHC plan? Well, probably that's right, because having a diagnosis is neither here or there. We know that in order to have special educational needs, you either have to have a learning difficulty or a disability. So you don't need to have a specific diagnosis to have SEN. Of course, very often it's helpful to have a diagnosis because that indicates a certain type of need and a certain type of provision perhaps, but it's certainly not a requirement. And it certainly isn't sufficient on its own to say, well, because a child has, for example, a diagnosis of autism, they will therefore get an EHC plan. The parent has provided a private EP report as part of a request to assess, and that's been accepted as evidence of SEN. Can the local authority insist on their own report? Well, again, if we go back to the regulations here. That's it. Yes, that's the act. I'll do it this way. There. So we look again at Regulation 6. What they must do is obtain psychological advice and information from an educational psychologist. And so they are certainly not required to then go and ask their own EP service. If getting their own EP report means that that would take them outside the 20-week time frame, and there is already a private EP report which they can rely on to provide the advice and information, it may well be irrational and unlawful for them to insist on getting their own EP report. So it's certainly an issue that can be pushed back on. Again, I think what I'm hopefully showing here is what's so important is to focus on the specific wording of the legislation, because the legislation doesn't say that the local authority have to ask their own EP service. It says from an educational psychologist. What can be done if a local authority has removed specificity from special educational provision in plans, ours in particular? Well, this is difficult because there are two options here. One is appeal each case to the tribunal. And the advantage of that, of course, is the tribunal can just order it all to go back in. But the problem is that not every family is going to be in a position to appeal for various reasons. If you can establish there's a policy, whether because of practice or because it's been written down, you could look to bring a judicial review claim. The immediate response to that from the local authority is going to be almost certainly you shouldn't do that, you should just go to the tribunal. But I think that the administrative court might be willing to consider a judicial review if you can show that in fact this is a systemic problem and there's systemic illegality at a policy level. And so the short answer is you'll need to get specific legal advice as to whether you're in that kind of situation. If new evidence is provided while the plan's in draft form, can you insist that that's taken into account and included before a plan is finalised? You could certainly strongly encourage the local authorities to take it into account, on the basis that if they don't, you can just appeal to the tribunal and put it in as evidence there. So it'd be completely pointless for them to ignore it. Can you insist that it's included? Well, you can insist that it's included as an appendix in section K. You can't insist the content is lifted into the plan, because that's obviously a matter for the local authority. Oh, a very interesting question. If your child's on a waiting list for an ADHD or an autism assessment, for example, could you request this brought forward as part of an EHC needs assessment? Probably not, no, because you don't need a diagnosis in order to provide the information and advice that's required under Regulation 6. But I have had a similar question asked in terms of, for example, social care. We've got to respond within 6 weeks, but it normally takes us much longer than that to do social care assessments. To that, I would say, well, you have to respond within 6 weeks. You have to be able to provide the advice and information, therefore do the assessment more quickly. So there may be some situations where effectively waiting lists get jumped or put aside, but I'm not sure that one is necessarily one of them, because there's no requirement for there to be a diagnosis in order for this process to be completed. Having said that, I can certainly see why parents would say, well, you can't properly produce the EHC plan or decide whether there should be one until you know whether my child has, for example, autism. So it's certainly an issue that's well worth pushing, but I'm not sure at the end of the day you'd be able to show that there was a legal obligation to bring the child up a waiting list. It's great there are still so many questions left. I'm very conscious that we're about to run out of time, so I'm afraid I'm going to have to stop shortly. I'll just scan them, and apologies for those of you who've asked a number of questions. I'm focusing on those who I haven't responded to yet. Here's an interesting question. An EP report has been updated for 3 years. Should it be updated for an annual review? Not necessarily. There isn't a requirement for every annual review to be informed by new advice from every relevant professional. But if there was a good reason, then of course, new EP evidence should be obtained, or parents could ask for a reassessment. And if that's accepted, then of course, all the new advice would need to be obtained. And a question about mediation, which I haven't spent a lot of time on. Concerns about a final EHC plan, suggestion that mediation may not be practical as there's no new evidence and therefore it's better to go to appeal. Is this correct? I am very concerned about mediation in the SEND context, because mediation is usually very effective where there's a quality of arms. So where the two parties that are mediating are relatively equal, like two businesses, for example, mediating a commercial dispute. There's no equality of arms in the SEND space. And also, why should families be compromising what their children are entitled to? If there's a need, then the provision must be made to meet that need. And why should they agree to have 3 hours of speech and language therapy if in fact the evidence says that 5 hours is required? So I'm really not naturally drawn to mediation in our area. I can see why it can be useful in certain cases. I think it's appropriate that it's considered, but I also can see why in many cases it's unlikely to achieve much, and families would be better off just to go on as quickly as possible to the tribunal, bearing in mind it takes many weeks, months even, to get the decision out of the tribunal. So yes, anything that slows up the process, I'm very concerned about, and that's why I'm strongly opposed to the suggestion in the Green Paper that there should be any sort of mandatory mediation, apart from being an oxymoron, I think, contradiction in terms. It's and potentially a violation of people's civil rights and human rights. That's controversial. I think it's just an extremely bad idea to make people mediate when they don't want to do so. And the tribunal exists for a reason, which is to adjudicate on disputes between parents and local authorities. So yes, I could spend a whole session talking about mediation, but I hope that gives some kind of helpful steer. So I'm afraid that brings me to the end of the time that's available today. I'm conscious there are still questions coming in. I hope it's been a helpful run through of the key law in this area. Just to recap then, I think that some of the key messages to take on board are that the threshold for the EHC needs assessment is not high, and that in the vast majority of cases where local authorities are challenged, assessments are ordered. The threshold for an EHC plan to be issued is of course higher. There has to be a reason why it's necessary for the special educational provision to be made in accordance with the plan. But the prize is significant because if a plan is issued, there is a duty to secure all the provision in it, and there's a duty on the school to admit and the local authority to fund. So there is an obvious reason why EHC plans continue to be seen as an important part of the jigsaw, and they do provide the clear statutory entitlement to provision that is missing if the child or young person is only being supported at the SEN support stage within the code of practice. So that's all we've got time for today. I'll hand back now to our organisers. Thank you again very much for having me, and we've got more in the series, I think, Sharon, haven't we, coming up?
Yes, we have. We've got one each month, haven't we? And hopefully one on the SEND review. So thank you, everyone. Thank you, Steve, again. And we look forward to seeing you next month. As we said, we'll try and get the recording onto the YouTube channel, hopefully before the weekend. So we'll get that IT, once it's been downloaded, we'll get that to you. And there's lots more that Steve have done over the years that are still on there as well, and last month's session. So please have a look, and then you can dip in and out of them whenever you want. Plus there's lots of others on there as well from our specialist OTs and things like that. So once again, thank you, everyone. I hope you've benefited from it, and we'll send out a survey to get your thoughts, and we'll be grateful for some comments for our funders that have given us the money to be able to do this today and future ones. So I'll end it now. Take care, everyone.
Thanks,
I'll see you
Thanks,
next
everyone.
month.
Good luck, everyone. Cheers now.